Ladies and gentlemen, welcome to the Bullpen. In the Bullpen today, we have attorney Ashton Cohen, host of Electile Dysfunction. It's a podcast, interesting wordplay there. Writer at Bold TV. Mr. Cohen, good to have you, attorney. How are you, sir?
Appreciate it, Dr. Richey. Thank you for having me on.
Absolutely. We're going to chop it up about the US Constitution, the United States Supreme Court, and gun laws or gun control, however you want to term that. I don't want to presume what you know or believe about this dynamic, especially in light of recent decisions. So if you would, give me your sentiment and I will then opine.
Okay, well, one of the reasons why it's been newsworthy as of late has been this Bruin case, which essentially allows for concealed carry requirements in the various states. So the Bruin case, for example, just invalidated a New York law which prohibited individuals from getting licenses to conceal carry in public unless they were able to show proper cause. And the Supreme Court had taken a pretty monumental decision on this that we've been waiting for a long time, basically saying that, well, you can't have these subjective criteria by which to issue a gun permitting license. So there are about 43 states in this country that are shall issue jurisdictions where if you meet objective criteria, you can get a license to carry a firearm in public for self-defense purposes. About 6 or 7, including New York, who was the subject of this lawsuit, say, no, you actually need to meet what they call proper cause. And the problem with proper cause is that it's an undefined term, it's a subjective criteria. And what is proper cause? Well, proper cause is whatever a sheriff or a police officer says it is under the circumstances on a case-by-case basis. So it's led to this absurd conclusion where in places like California, where I live, where rich people, politically connected people, people whose daddies paid for the sheriff's reelection or who are in bed with the state senate or fund some of the local politicians in the state, they can get a permit to carry a weapon. And criminals obviously can, by virtue of being criminals, they don't care about the law. But somebody like me, who's an attorney, who literally an officer of the courts, would be denied a permit based on subjective, arbitrary standards.
Let me ask you this question, because you talked about the ruling. Clarence Thomas has his opinion. He actually cited the terminology self-defense. Do you agree that we have a right to bear arms based on a dynamic of self-defense, attorney?
Yes.
Okay. Where is that in the Constitution?
Okay, so the right to bear, the right to bear arms, the Second Amendment, has always been understood to include the self-defense right.
Attorney, in all due respect, my question is, where does it say that the right to bear arms is a self-defense element of the US Constitution?
So it's the right of the people to keep and bear arms, of course, on the Second Amendment. And so,
no, sir, that's not the reading of the Second Amendment. The Second Amendment says, for a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms should not be infringed. Clarence Thomas, you're an attorney, sir. Clarence Thomas referenced self-defense. Self-defense is not even worded in the US Constitution. He made that part up. In addition to that, in 2008 is when it changed with the decision of District of Columbia versus Heller. And that's when the court for the first time actually concluded that the Second Amendment is a right to individuals. So up until 2008, there was a massively different interpretation of what the Second Amendment actually meant, sir. So when a Supreme Court justice cites self-defense as a reason to overturn local jurisdiction as it relates to gun policy, do you not find that problematic that he cited something that's not even contextualized in the Constitution itself?
Okay, so let's look at the context of the Second Amendment and the Constitution, which the Supreme Court did in this case as well. So the Second Amendment comes from the 1689 British Bill of Rights, right? That's where it's a derivative of. Prior to the Second Amendment, there were about 7, and immediately after the establishment of the Second Amendment, there were 7 states that codified the rights for self-defense purposes. It's always been interpreted as a self-defense amendment, just as every other bill of rights.
In all due respect,
just like
that's
every
not
other
true.
statute. That is true. Every other amendment in the Bill of Rights, every other amendment in the Bill of Rights applies to the rights of individual people, not the collective militia.
Okay.
This canard about the militia being, the Second Amendment being
who wrote the Second
subject
Amendment
to the militia.
Sir, who wrote the Second Amendment ratified in 1791?
So it comes from Thomas Jefferson. So Thomas Jefferson wrote the essentially the corollary in the Virginia Constitution.
No, sir, it was James Madison.
Copy.
No, sir.
James Madison wrote the Constitution, but the actual Second Amendment, if you look at the Virginia Constitution, it was written by Thomas Jefferson. They took it almost word for word from the Virginia Constitution.
Sir, the Second Amendment ratified in 1791 was proposed by James Madison. The reason why that part
James Madison wrote the Constitution, yes.
It was
taken from Thomas
directly, sir.
Yes.
My point is, it was proposed directly by James Madison. James Madison, you said the interpretation of the constitutional dynamic has always been the same. That's not true. When James Madison proposed the creation of the Second Amendment, it was to do one thing, and he went on record with it, to counteract a tyrannical government. That is what it was for. So when you say it's always been the same interpretation, that is not true. They've had different interpretations, and not until 2008 did the courts recognize this as an individual dynamic. So, sir, it has not always been interpreted the same. That's why you had dissension in the circuit, you had dissension in the rulings of federal courts, and that's why in 2008, the US Supreme Court had to get involved. You had different conclusions at that time.
It's always had a dual purpose. I mean, I think it's, we shouldn't get hung up on Thoreau. If you look at the Virginia state constitution, you'll see that Thomas Jefferson wrote that, and the Second Amendment's almost a word for word copy from the right to bear arms statutes amendment in the Virginia Constitution.
All right. So, let me ask you this question. I think it's really interesting. Do you believe, you cited constitutional carry or concealed carry? Do you believe in constitutional carry?
Yes.
Okay. So constitutional carry basically says, listen, because bearing arms is a right, you do not need to go through a bureaucracy. You don't need to go through a permitting process. You can just go ahead and get a gun and bear arms because it's a constitutional right.
That's not correct. No.
Okay, go ahead.
So you can still have objective criteria, and the Supreme Court made that clear. So
it depends. It depends on the state. So I'm talking about state laws like Texas, which they believe in constitutional carry. They've already passed a law. It is legislation. It is law. And according to their version of it, you have a right to bear arms without going through a prerequisite of government, sir. Is that incorrect?
I'm sorry, can you repeat? You broke up on the last bit.
Okay.
I heard.
According to the current law in places like Texas and a few others, constitutional carry means you don't need to go through a prerequisite process of government approval or permitting in order to carry and conceal a firearm. Am I correct or incorrect?
Right, of course, and you can't be a
so I'm
felon or
correct.
domestic abuser,
Thank
of
you.
course, right?
Now, you believe in constitutional carry, meaning because it's a constitutional right, you do not need a process to approve you to exercise that right. Am I right so far?
No, I think that a process of demonstrating, certain hours of training, which many states have, I think that's
okay. So you disagree with the Texas version of the law then, and you disagree with the Republican version of the legislation, and you disagree with the Georgia version that just got passed. So you disagree with them.
Yeah, I think it's reasonable for every state to make their own judgment. But if you were to have, some of these states have, basic requirements that you need to demonstrate, All
right, so are you saying that maybe there's some light here that we may agree on? Are you saying that states which do not require any level of prerequisite, those states you disagree with those states and how they're applying the law? Is that what you're saying, or how they're applying the constitutional standard?
I think they have the right under the Constitution to do so. If I were to craft the legislation, I would probably have just a basic competency of demonstrating your ability to have a firearm and to handle it properly.
Do you agree with their logic in the interpretation of the Constitution? Like, for example, attorney, when the state says we actually have the right to eliminate all prerequisites, all permitting, constitutional carry means in this state, you can just carry a gun because you choose to. Do you agree with how they're reading the Constitution to allow them to make that law?
Right, yeah, so the Second Amendment doesn't put any prohibition on being able to carry a weapon, but the Supreme Court has said has essentially given the okay to do things like prohibiting domestic abusers, obviously felons from being able to access weapons, things of that nature, which I agree with.
All right, so the logic is, it's okay. It may not be your cup of tea, but it is constitutionally, I guess, viable when they interpret the Constitution to say, because this is a right, you do not need to go through a prerequisite of government to exercise it. Here's a question I have for you, attorney. Is voting a right?
Yes.
Okay. Do you now advocate that in order to exercise your right to vote, you do not need to go through any prerequisite of registration, of identification producing, or anything, because it is in fact a right as well?
No, of course not. You have to be registered. I mean, I just
but wait a minute, that's not what the Constitution says, sir.
I had to go through a background check. I had to go.
But wait a minute, dear brother, attorney. You just cited that the Constitution does not prohibit or provide additional auxiliary information or relevancy to you bearing an arm. That's correct. You can just do it, right? So you agree with that. The Constitution also does not create barriers to you participating in elections. However, we have statutorily done so, and you're okay with that. So explain to me why you're not okay with having common sense registration for firearms, but you're okay with having registration to exercise the right to vote.
Well, if we're talking about sort of a national database, is that where you're getting at for firearms?
No, sir, I'm not talking about a national database. My question stands as asked.
Of course, you have to pass background checks, right? You have to be a free citizen.
So what are you talking about?
Yeah, so I'm fully in support of obviously, going through a process where you get background checks and.
But I'm not even talking
keeping
about
them out of the hands of domestic abusers and all that.
But my question to you is very simple. Do you not see the hypocrisy in state governments passing laws that say, okay, this is a constitutional right, because it is a right, we're now going to eliminate you needing to provide registration, engage in some government prerequisite to exercise the right. However, it makes perfect sense to have those same restrictions where you have to register, you have to provide documentation in order to exercise your right to vote. That makes sense, okay? But for individuals like yourself, the other part doesn't. You mean to tell me that it makes more sense to have to register to vote than you have to register in order to obtain a firearm?
Do you think
conceal carry?
Sure. Do you think that going through the registration process to vote is more of a burden than having to go through background checks in order to purchase a firearm? Because we have.
You don't have to go through, sir. That's another misnomer. I'm going to correct you on the record. 41% of all firearm sales in the United States of America are done so without the use of a background check, because they don't have to. Private to private gun sales, and the gun show loophole provides that opportunity. Well,
the gun show loophole is like less than 1% of all gun purchases. So if you go through
all gun sales in America,
firearm dealer, go through a registered firearm dealer, you have to go through a background check.
41%.
I'm not sure you're getting 41% of firearms are gone without a background check. Where do you get that information from?
41%. You can check it out when we get off the show. Guarantee you I'm correct. 41% of all gun sales in this country do not mandate a background check because they're private to private sellers of guns. So it's not required. It's ironic that even if you sell somebody a car, you have to do what's called due diligence, a good faith effort to make sure they can actually drive it. You got to do that. That's law, okay? Got to do that. Most states say that's just law. Makes sense. My point, attorney, is that when you start getting into the weeds of these particular rulings, they don't add up to linear logic. There's a deviation from the thought and how it started. So there's one thought that says the right to bear arms is constitutional and cannot be infringed on by state governments, so there's no registration needed. And then the right to vote, however, can be infringed on by government and registration is required. Those two dynamics coexist in hypocrisy. Do you not agree?
Yeah. So if you're asking me if I think that all background, every gun you purchase from authorized dealer has to go through FBI background check, I completely agree with that. With a private sale transfer, if we're talking about a son giving it to his child, or that's okay, an adult child or something, an adult, that's fine with me. But I completely agree. You need to go through background checks in order to purchase a firearm.
All right, but once again, you see the hypocrisy that I'm bringing to your attention. How you have one side that says, listen, eliminate prerequisites, let people constitutional carry, but they don't believe in constitutional voting. Do you not see the hypocrisy I'm bringing to your forefront?
Do you think registration is a burden so much so that it violates a constitutional right to vote?
No, is registering or applying for a permit to conceal your firearm, is that unduly burdensome, sir? Is that what you're saying? Is that too much to ask?
Registering. applying for a permit to be able to constitutionally carry, to be able to carry your firearm, yeah, I think that's fine.
Okay, so you don't think?
I think that's fine as long as it's based on objective criteria. I think that's fine from a constitutional perspective. The problem with places like New York and California is that it's subjective criteria based on what they call good cause, right, or proper cause. And that could be anything. But if it's objective criteria, I'm perfectly fine with that. And the Supreme Court, by the way, said if New York wishes to have stricter permitting, they require, for example, 50 hours of training before you can get a license. That's fine. They're permitted to do so. They're just not allowed to have subjective criteria in order to prevent people from being able to carry a weapon on themselves.
What's the difference between subjective and objective in the context you just laid?
Yeah. So objective criteria is basically, it'll say, okay, if you basically do these things like get the X hours of firearm training, pass a moral character exam, pass this test, you get the license. Subjective is basically where they don't tell you what criteria you're going to be judged on, and it's up to the whims of a sheriff or a cop to. Yeah,
but that's not what the New York case said. The New York case actually did have a criteria. You may not like it; it was extremely restrictive. But it did have a criteria.
Right.
Well, it's subjective. See, here's the thing: all laws, sir. You're a law school graduate. You have studied how laws were and still are very subjective to the authors of them, written by legislatures who were very partisan and opinionated, sir. So when you say objective versus subjective, you're really saying two words that have no difference in the context of the law, because there are many laws that we follow today and that we have to adhere to that are in fact subjective, even though we will call them objective. That's why I wanted you to split the difference in that. What makes it subjective to objective? And I don't think you can actually tell me the line here.
Well, no,
what's the line?
So with objective criteria, it says if you do X, Y, Z, you get the license. With subjective, it says if you do X, Y, Z plus you satisfy some random police officer's viewpoint, then you may get a license. That's what separates it. So objective criteria that's spelled out beforehand that you can either satisfy or not will make it objective, right? So the elements have to be spelled out.
So let's go back to some legal theater here. You're saying that if New York right now passes a new policy, a new gun control dynamic, and they simply spell out 20 different things you got to do in order to carry in their jurisdiction, are we now constitutional again?
Should be. I mean, it depends on exactly what it is, but if it's within
No. You didn't say it depends on exactly what it is. You just said it depends on if it's exacting. So if I have 20 exacting things that you must do in order to carry in this jurisdiction, am I not back constitutional again?
So again, it would have to depend on. I mean, like if you were going to be subjective again, or if it was going to be something so out of bounds, obviously.
If it's 20 very specific things that I'm saying you have to do in order to obtain a permit to carry here, does that not bring me back, according to the ruling of the court, to constitutional muster?
So it would, so long as it wasn't something just completely out of bounds, not a reasonable subject that you're not being able to exercise your Second Amendment right. But there are 50 states in this country. There are plenty of examples of other states you can look to that have criteria, and you can just implement those. And you can make them a bit more stringent, of course.
Or you can just do it the way
like firearm training.
Or do it the way your local community demands it be done, because you have to serve a local constituency. You can do it that way as well. Attorney, it was a pleasure, brother. Thank you for being on the show.
Appreciate it, Dr. Richey. Thank you so much.
Absolutely.